Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast, a special edition, I suppose, because I'm very grateful to have Professor Nick Hopkins on the discussion with me today, Commissioner for Property, Family and Trust Law at the Law Commission, and of course led the recent report on Modernising Wills Law. Nick, fantastic to have you on the podcast. No prizes to anybody for guessing what the topic of conversation is today.
Thank you very much, David. It's great to be here and to have the opportunity to discuss our wills report that we released into the world just over a week ago and have been watching with a huge amount of interest to see how it's been received.
Well, we'll get on to that. In the first instance, tell us a little bit about yourself, please. And we're very fortunate to have you because you're actually leaving the Commission fairly shortly as well.
I am, yes. So I was appointed as a Commissioner nearly 10 years ago now, back in October 2015. And our wills project was actually one of the first projects that I began. And as commissioners, we're appointed for 5 years, renewable once. So my time is nearly up, and I'm leaving next month to take up a chair at UCL. So wills has really bookended my time as a commissioner, and it's the last report that I'm publishing before I leave.
Serendipitous then, as you say, that it almost starts and ends with wills. And this is, as you say, a 10-year journey. Talk us through how that timeline has developed, because it started and then it stalled because you were asked to look at family, weren't you? You've had COVID as well, which no doubt had an impact. It seems to have taken us an awful long time to get to this point.
It has. The project has had a bumpy road, but those bumps have not really been to do with the project or indeed anything to do with wills law. So we took the project on back in 2014 as part of our 12th programme of law reform, but we have paused it twice to prioritise work on weddings law. So some initial work was done back in 2015, but the project wasn't properly started then when we were asked to do a scoping paper on the law around weddings. That took the rest of 2015. So we began the wills project properly in 2016. We had our consultation in 2017, and it was after then that we agreed to a request from government to pause the project so that we could do a full law reform project on weddings law. And that project took from 2019 to 2022. So that was longer than expected because COVID intervened. And of course, COVID had a particular impact on weddings in the same way that it had a particular impact on wills. And so we had to address those issues. So after we published our weddings report, we returned to wills. That was in the autumn of 2022. And we did a supplemental consultation in 2023 that was targeted on a couple of issues where we felt that since 2017, views might have changed. And so at the risk of making a virtue out of a vice, that pause has actually been beneficial for the project ultimately, because it was apparent to us that views around electronic wills and views around the current rule that a marriage or civil partnership revokes a will had changed in that period. And so we were able to update our consultation and take those changing views into account. So a delayed report, but our report and a draft bill is a culmination of all of that work and of those two consultations.
I find that reference that you make within the report to those changing views fascinating. Have you got any insight into why those views changed, particularly from 2017 to nowish?
Yeah, and they change for different reasons. So when we returned to the project, it was quite apparent to us, I think, that most of the topics we were dealing with are long-term issues, long-term concerns with law of wills, and that views weren't going to have changed significantly, or there was no reason to suppose they would have done. The electronic wills and the rule that marriage revokes a will were in a different category. So as far as electronic wills were concerned, COVID had really shone a spotlight on the difficulties of executing wills under current formality requirements during that really difficult period. And also during that period, technology moved on a lot, in part because of a response to COVID, but quite separately to that, technology moves much quicker than law. And the idea of an electronic will wasn't as novel anymore because a number of jurisdictions had introduced electronic wills in part as a response to COVID. So for electronic wills, it was the COVID pandemic that was the real impetus for changing views. For the rule that marriage or a civil partnership revokes a will, it was a different change, and that is that concerns around so-called predatory marriage, so where somebody marries a person essentially as a form of financial abuse, that person usually being old, vulnerable, and perhaps having lost capacity even to marry, let alone to make a will. Concerns around predatory marriage really came to the fore and were raised with us as part of our work on weddings law. There was a real concern that the current rule was actually providing a motivation for those engaging in predatory marriage. So different things meant that on those two issues, we felt that there had perhaps been a shift in views, and so we undertook the second consultation.
There's much to be applauded in the report, and so much in there. I mean, it runs to 500 pages. This is a sizable piece of work. Can you talk us through how the Commission arrives at the 30 or so recommendations that it makes from the myriad of options that you no doubt had?
This is the first comprehensive review of the law of wills for nearly 190 years. So there was a lot to consider. We haven't tried to replace the whole of the existing law. There's a lot of law, for example, governed by the common law that works well and people are happy with. So we've tried to focus our work on areas where there are concerns with how the law operates because of all of the changes that have happened in the near 190 years since the legislation was enacted. We've been guided by three key aims. Those have been to help ensure that testators' testamentary intentions are given effect, to protect vulnerable testators, and to provide greater clarity and certainty in the law. So those have been our three sort of guiding aims. And within that, we have looked at the law through extensive consultation that we've had. So that's been both through our two consultation papers, which have generated responses from a wide range of people interested in the law of wills, from representative legal bodies, law firms, practitioners, but also in terms of electronic wills, software providers, and in terms of some of the issues we're discussing, groups that represent vulnerable adults. So we've been guided through consultation and through a huge number of meetings that we've had with people directly engage with wills law throughout the duration of the project. So it's through that process that we've decided, not only which areas need to be examined, but also the final recommendations that we've made.
You mentioned electronic wills specifically, and that is an area that I think practitioners are very interested in, and there's a fair amount of contention around that area as well, because of course the concerns around capacity are there, as well as coercive control you've alluded to from the predatory marriage side of things as well. But I guess in the first instance, what to your understanding is an electronic will?
So in essence, an electronic will is a will that has been executed electronically and is then stored electronically. So it's a will that doesn't exist on a piece of paper. It's an electronic document in the same way that we've become used to other documents existing in electronic rather than paper form.
You describe that electronic wills might need some sort of additional formality requirements, but there's some vagueness, if you don't mind me saying, around what they might look like. Why is that? Is that you've left that to practitioners to kind of find the answer to that, rather than it being the Law Commission's role to do that?
Our guiding principle has been that electronic wills need to provide the same level of protection to testators as a paper will provides. So that's been our benchmark, the same level of protection. We're not holding electronic wills up to a higher standard. And so we've looked at what the formality requirements for a paper will achieve, and we thought about how they can be achieved in the electronic context. And so essentially we've said two things. One is that the electronic will have to meet the same formality requirements as a paper will in terms of being signed and witnessed, but that where the law requires the presence, for example, of witnesses, that could be done remotely rather than in person. So that there's an option there. It could be in person, but could also be remote. But in addition, we said that there are some other requirements that electronic wills need to meet. And those are that it must be executed on a reliable system that does three things. That first of all ensures when the will is signed that the person signing the will is linked to their signature, makes that direct connection between the signature and the person. Secondly, that the electronic will can be distinguished from any copies of it. And thirdly, that the will can't be altered or destroyed unintentionally. Now, the approach we've taken to those requirements is one that we call technology neutral. So this is an approach that the Law Commission has taken in other projects when it's dealing with sort of technology and digital property. Technology moves much faster than the law does. And if we try to prescribe in the legislation what an electronic will look like, it would be out of date before it got through Parliament. The technology moves too quickly. So the approach we've taken here, as we've taken elsewhere, is to set out in the legislation what functions and what standards must be met, but to then leave the operation of that to be developed over time. But we've coupled that with what we call a regulation making power. So a power for the Secretary of State to issue regulations saying how those requirements are met. But this technology neutral approach is one that we've used, for example, in our work on electronic trade documents. Now, electronic trade documents are completely different to wills, so that there's no comparison there. But this approach of setting out what the reliable system needs to do and leaving that to be developed in practice is the same approach that's used in the Electronic Trade Documents Act 2023 that was also a Law Commission piece of work. So no, I can understand the concern within the profession that there's, assuming our recommendations taken forward, there's going to be this new thing called an electronic will, and people can't quite picture what it's going to look at. But that's not because we fudged it. That's because we want the technology to be able to develop and the law we have, the primary legislation, to remain fit for purpose into the future.
I understand that, and there's a balance here between the formalities that you've described and not making it difficult to make a will. I mean, ultimately, you can make a will on the back of a fag packet, provided it's that the formalities are followed. But is there a missed opportunity here to increase the security of will writing, to tackle that challenge that you've identified around predatory marriage and around coercive control?
I don't think so. I think it would be wrong to hold an electronic document up to a higher standard than a paper document. Paper isn't infallible, and nor are electronic documents. But as long as the same level of protection is provided, we think that that gives the freedom to allow electronic wills to develop. And we have in drawing up our recommendation, we have taken into account that we're dealing with a unique document, that wills are unilaterally executed. You don't need to have legal advice. As you say, you can write it on the back of a fag packet, or in the past, and I guess still today, you could walk into WH Smith's and pick up your wills pack. They're only going to be challenged after the testator has died, and forgery or fraud in this context is more likely to be conducted by somebody known to the testator than by a stranger, and possibly somebody who the testator looks to for advice and assistance. So we've taken all of those into account, and I think our requirements for the reliable system are very much driven with those in mind. And so the idea, for example, that the electronic signature has to be connected to the testator at the time the document is signed. So this can't be something you have stored on your phone that a family member can take and apply to a document without you knowing. There will have to be that record of the fact that this was you signing. We think in terms of what formalities do, electronic wills will provide the same level of protection as paper wills. Those other concerns, but what do we do to help vulnerable testators, for example? We've got other recommendations that we hope will help with that as well. We can't put everything on the formalities. We have to look at how our new wills law as a whole is going to protect people.
Let's move on and talk about some of the recommendations which appear to open up doors to further contentious action. We've seen this massive rise in contentious activity. So things like dispensing powers and rectification, and dare I say electronic wills, seem to potentially open a door here that you clearly feel we need to.
Yeah, it's an interesting one. A massive rise. I think people would challenge that in the sense that, yes, there has been a rise in contentious probate claims, but the percentage of wills that end up in a dispute is still tiny. Most wills are admitted to probate without difficulty. So no, I'm not denying that rise is there, but I think it kind of has to be seen in context. We don't think that our recommendations are going to lead to a significant increase in contentious probate claims. Where they do lead to an increase, that's going to be in order to give effect to testamentary intentions or to protect the vulnerable testators more. And so we think a small increase for those purposes is probably a legitimate one. To take the examples you gave, and starting with the dispensing power, these are powers that exist in a number of other jurisdictions. And so we've looked and we've spoken to people in those jurisdictions to see how the powers are operating. And we've had reassurance from them that they haven't given rise to any disproportionate increase in litigation. That this is a power that recognises that formality requirements aren't an end in themselves, they're a means to an end. And a lot of people have heard of instances where some technical error in a will being executed has meant that will can't be given effect, even when it's perfectly clear what that person's intentions were. So we hope that that power is going to help in that respect. In terms of electronic wills, at the moment, there is no clarity as to whether an electronic will is valid. It's not clear what the position is under Section 9. We're certainly not aware of anyone who's trying to push that point at the moment, but there is a bit of a vacuum there. So filling that vacuum with some clear law that sets out what an electronic will have to achieve in order to be valid should be beneficial. Rectification is an interesting one, really, because, as you'll be aware, at the moment, a court can rectify a will where it doesn't give effect to the testator's intentions because of a clerical error or because the drafter hasn't understood the testator's instructions. But the court can't rectify where a drafting error has been made. So in other words, where the testator's instructions have been understood and where the drafter has consciously chosen to use language that in fact doesn't give effect to those intentions. Now, this has been criticised because what it means is that the state of mind of the drafter can determine whether the will can be rectified or not. So if your drafter is careless, it can be because they make a clerical error. If your drafter is thoughtful and careful, then it can't be because they make a drafting error. Now, when we published our consultation paper, our initial view, in fact, was that the law shouldn't be reformed. We thought that in the case of a drafting error, it was better to look to the law of negligence. And we are also concerned of opening up potential floodgates for litigation. Now, we work through consultation, and it was through consultation responses that we were persuaded that both of those concerns were in fact misplaced, that negligence isn't the answer here because the outcome then depends essentially on the drafter's professional negligence insurance, and also doesn't itself give effect to the testator's intentions because it means their estate goes to the person who they didn't intend it to go to, and the person they did want to benefit gets the negligence claims. We're persuaded that negligence isn't the answer, but we're also persuaded that making this change is not in fact going to open up the floodgates to litigation. Rectification is a discretionary remedy. The courts need convincing evidence of the testator's intention. And when we looked at similar jurisdictions within England and Wales, in particular, the ability to rectify voluntary settlements, it's apparent that the court's approach is actually very cautious. So in fact, I think rectification is an instance where our initial concern was this is going to open up the floodgates, but where consultation responses have persuaded us that no, in fact, that's not going to happen, and that the law at the moment isn't really working in a way that people find satisfactory.
What I often take away from conversations like this, and particularly around litigation, is that the onus has to be on the professional to retain the evidence of the testator's intentions and the evidence of their capacity, all of that sort of wrapped together. Does the Law Commission kind of lay out what its expectations are around that?
In terms of expectations of professionals, the Law Commission doesn't set out how professionals should do their job. So I suppose we take the view that is a matter for regulators and organisations that sort of represent professionals, whether solicitors or will writers. So we don't set out how we think professionals ought to do their job. We set out what we think the law should be and should do, in order, for example, to protect testators, in the expectation that professional practice and professional requirements will then develop to meet the legal requirements in the way that they would as a matter of course, where, for example, the law changes through the common law.
On the discussion point about courts and taking these issues, whether it be rectification or whatever it might be, through to the court system, the criticism there is twofold, really. One is that the courts are overworked and are already busy. But secondly, that the courts simply don't understand some of this stuff either. Is that a fair criticism? Is that something that the Law Commission might or should have taken into account?
I mean, we're certainly always conscious of the workload on the courts and delays in litigation. We question at every stage if we think that something we're recommending could lead to an increase in litigation. We question whether that increase is legitimate and what impact it's going to have. There's also a bit of a balance here. I think that we've highlighted that rightly areas where our recommendations could lead to a bit of an increase in litigation. But stepping back, when you look in the round at us providing a modern, clear piece of legislation, modern and clear law should reduce the incidence of litigation, because it's apparent on the face of the legislation what has to be done. So we hope, looking in the round, that there is going to be an improvement here. In terms of the court's ability, I mean, the wills law is heavily imbued and developed by the courts. Courts have indeed provided clarity where they can in the context of legislation that doesn't always provide that. So I certainly don't think we have any doubts or concerns about the ability of the court to apply what we set out in our draft bill. Which
rather neatly leads us on to capacity, because you're, as part of the recommendations, suggesting that we move forward with a single understanding of capacity, which is enshrined in the Mental Capacity Act, and incorporate elements of Banks v. Goodfellow. And perhaps you could explain sort of quite what that means in the context of the recommendations, rather than having this two-pronged system that we have currently.
Yeah, so at the moment there are two tests of testamentary capacity, and which test applies really depends on who is asking whether the testator has capacity and why they're asking that. So if a solicitor or will writer is considering whether their client has testamentary capacity, they apply the Banks and Goodfellow test. And if a will is being challenged on the basis that the testator lacked capacity, the court applies the Banks and Goodfellow test. But if the court of protection is being asked whether it's in the best interest of a person to make a statutory will for them because they lack capacity to make their own will, then the Mental Capacity Act test is applied. And you could have a situation where the different test is being applied to the same person, and the court of protection to ask if a statutory will should be made, and then subsequently to ask whether a will that they did execute is one that they had capacity to execute. So we don't think that is satisfactory, and so we've recommended that the Mental Capacity Act is applied in all cases. That is a test that is more modern, that professionals who assess capacity and may ultimately be involved in considering a person's capacity to make a will would be familiar with applying. But we also acknowledge within this that Banks and Goodfellow does capture the things that a person needs to know in order to make their will. And so we've recommended that elements of that test are incorporated within the Mental Capacity Act Code of Practice, so that if you like, we're not throwing the baby out with the bathwater. We're kind of capturing that really useful learning from the case law in the context of a move to the Mental Capacity Act. Now, I mean, our expectation in this respect is that the test of capacity is going to change. It's not going to be higher or lower, but it is going to be a bit different. And so it's possible that that at the margins and in relation to testators who are at the margins of capacity, there may be some who would have capacity under Banks and Goodfellow but don't under the Mental Capacity Act. But also there will be some who have capacity under the Mental Capacity Act who may not have done so under Banks and Goodfellow. So it's a change in test. We don't see it as one that's going to lead to significantly different outcomes, but it is a move to what is now a much more familiar test to those other than lawyers who are involved in making decisions about a person's testamentary capacity.
And the instruction to the judiciary then is to take the Mental Capacity Act as the benchmark.
Yes, yeah. And of course, a code of practice isn't law. So the law will be you apply the Mental Capacity Act, but the code of practice will capture the learning we have through Banks and Goodfellow.
In the course of a 45-minute podcast, we are not going to cover the extent of the recommendations in the report. But as we kind of move towards a close, I want to touch on where we are left in terms of intestacy and any thoughts you have about how the Law Commission could progress that. We are in the midst of almost a cohabitation crisis. There is very, very little rule and law and regulation around protection for cohabitees. You make recommendations around changing the rules on gifts in the report, for example. But is this a missed opportunity? Is it a case that you simply couldn't tackle everything? What do they say? You can't boil the ocean.
Yeah, I mean, for all of our projects, we work to terms of reference and we agree those with government, and then we work independently as we develop our recommendations. Wills is a big topic. That this is 190 years worth of updates in one go, essentially, and that's quite big enough to do in one. So our terms of reference to this project were about wills, not intestacy. We have, of course, looked at intestacy before. So we had our report on intestacy and family provision claims on death, and our recommendations, or most of our recommendations in that report, were implemented in 2014. What wasn't implemented at that point was the recommendations we made about intestacy and cohabitants. And as you say, there is a wider issue there about the extent to which cohabitants should have financial claims on each other at the end of the relationship, whether the relationship ends through death or whether it ends through a relationship breakdown. We have looked at the wider issue of cohabitants before in our 2007 report, and we know that government has indicated that it wants to take forward reform for cohabitants. We don't, of course, know what form that reform is going to take. So there are wider issues there that couldn't be dealt with in a review of wills law. But what we have done here, and what we do, I think in all of the projects we undertake, is when we're looking at issues relating to family members, we do take into account that cohabiting relationships are so common these days. So when we're looking, for example, at the fact that gifts to the spouse of a witness are not valid, but there's no equivalent provision for gifts of a cohabitant of the witness, that is something where we think that that there's a case for aligning the positions. So we can look at particular issues in the wills context, but those wider questions about how the law treats cohabitants go way beyond the law of wills. We have looked at them separately in intestacy and in terms of what happens on a relationship breakdown. But reviewing wills is big enough for one project.
You talk there about aligning the report's recommendations with society and with changes to law elsewhere. If I can challenge you, Nick, on the recommendations around reducing the age at which you can make a will from 18 to 16, because that kind of stands out a little bit. That doesn't align with other areas of law where you have to be 18 to vote, for example, and lots of other sort of examples of being 18 as a line in the sand.
Yeah, I mean, when we look at what happens in other countries, other jurisdictions, there isn't necessarily a link between the age at which somebody becomes an adult and is generally treated as an adult in law and the age at which a person is able to make a will. It's as low as 12 in Scotland, for example. We're not expecting lots of people aged 16 to go out and make a will in the same way that people don't at 18 or indeed 21. But what has been raised with us are the really tragic instances where children have assets or where children want to be able to decide who makes decisions about their body after they die, and where these are real pressing concerns because the child has a terminal illness, and where the intestacy rules are simply not going to accord with their wishes. That could be, for example, because one of their parents has not had any role in their life. So we think there is value in reducing the age of testamentary capacity to 16. The testator would still have to have testamentary capacity in the same way that somebody aged 18, 21 or 80 or 90 has to do so. But if they do have testamentary capacity, then we think there is a good reason to reduce that age to 16. And indeed, we've made a recommendation that even for younger children, if a court, if the family court decides that they are competent to make a will, then they should be able to do so. So we see it as a means of ensuring that testamentary wishes are given effect.
It's a reactionary opportunity rather than a proactive.
Absolutely, designed really to deal with with these really difficult circumstances where the ability, for example, to choose that the parent who has cared for the child is also the parent who inherits their property and who decides what happens to their body after they die, can be really significant to that young person.
One of my favourite stories about this particular issue is, of course, the darts player Luke Littler, who has amassed this fortune but simply cannot at the moment do anything with it.
Yes, and I expect there are various footballers and celebrities and influencers who fall within that category. I mean, I guess a lot of them will be the same as the 20, 30, 40 somethings who have amassed their assets and haven't made a will, even though that they can do and should do. But this is extending that ability to more people.
We're fast running out of time, and I'm very, very grateful for the time that you've spent with us today, Nick. Thank you. I guess just to finish off, really, and I appreciate your independence, and this is a loaded question, but two kind of final thoughts. One is, the government have a bit of a track record of ignoring the Law Commission, particularly on big subjects and big topics, and I'm thinking back to some of the work that, for example, has been done on financial remedies, recently, surrogacy. I mean, that's just been kicked down the road, hasn't it? So, I mean, you're hoping clearly that the government picks this up. But if there was a wish list, or if there was some key things that you really felt that we needed to implement, what are they? And then secondly, the chances then of it actually sort of being taken forward into law. There's the draft bill, of course.
Yeah, so I mean, this is, as you say, it's looking at a system change. It's looking at a piece of legislation to replace our 1837 Wills Act. When we do a law reform project of this nature, we're looking at the entire system. So I certainly wouldn't want to try and pick and choose between recommendations, because we've always had in our mind how these work together as a sort of coherent body of law. So what we hope is that government will pick up our draft bill and take it forward. You've mentioned other projects that I've led as commissioner and that we're still waiting to be taken forward. So thank you for another few years in therapy that may be required after that. Others have gone forward. Our track record is that around 2/3 of our reports have been implemented in whole or in part. So we think there's good reason to be hopeful. This is an area of law that is really important. It's one of those few areas of law that actually impacts everyone, or almost everyone, whether as somebody who can make a will, makes a will, or somebody who might benefit under a will. So we think it's really important that these areas are kept properly up to date. The law is running behind. There is uncertainty in the law. For example, over the status of electronic wills. So what we've provided the government with is a complete package of reforms and a bill to implement them. So we really hope that will be taken forward, and our track records suggests our hope comes with a good degree of confidence.
Nick, it's been fantastic to have you on the podcast. As I say, I'm very grateful for you taking the time out and chatting to me.
You're welcome. It's really great to see how much interest there is in the report. So we're really pleased that people are reading it, thinking about it, and want to learn more about it. That's great.
The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on todayswillsandprobate.co.uk. My thanks to Nick. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.